Thank you, Mr. Chairman. Mr. Horowitz, I see that the FBI continues to persist in characterizing the problem related to their the surveillance issues here as limited. And I see the FBI director's statement yesterday, the FBI statement yesterday makes it sound as if there's a limited problem. So let's just talk a little bit, if we could, about the scope of this problem with the FBI and how it is that the FBI came to be intervening in a presidential election while the election was ongoing in the fall of 2016. First, let me just ask you, when it comes to FISA warrants, surveillance warrants, are the targets of those warrants given an opportunity to defend themselves in court at the time the warrant is sought?
No.
So the court relies on who to establish the facts?
The FBI and the Justice Department.
So there's nobody there to contest the facts. I mean, the court only hears from one side. Is that correct? Is it normal in your experience, your knowledge, for the FBI to use as the principal basis for a surveillance warrant political opposition research paid for by a major political party?
I can't say that we've looked at any other FISA.
Have you heard of that being done before?
I haven't heard of it, and I can tell you there was obviously, as we lay out here, concern at the Justice Department among the lawyers involved as to that question.
And indeed, the FBI, of course, knew very well the nature and source of this Steele dossier. On October 11, 2016, after they were asked 3 times by a DOJ attorney, the FBI responded that Steele, and I'm quoting now, had been paid to develop political opposition research. This is right at the time that the FBI was going to the FISA court and asking for a surveillance warrant in the middle of a presidential campaign, correct?
That's correct.
So the FBI absolutely knew where this was coming from. What about the number of people involved? How many people at the FBI were involved in misleading the FISA court by your count, your estimation?
We don't have a precise number of exactly who knew what when, but there were 4 different FISAs. There's a case agent. There's a supervisory agent who are reviewing each. There was some overlap, so it's not 8. I think it's either 6 or 7 who had both of those responsibilities, some of which, to be fair, were more egregious than others in terms of the mistakes and the failures that occurred. And then, of course, as we note here, the reason we refer people up the chain is there is information flow up the chain. And even though those individuals didn't have direct responsibility under the Woods procedures, as managers and supervisors, we believe they had a responsibility to ask the probing questions they should have been asking and followed up on information they were getting to make sure they were in a position to effectively supervise.
I want to come back to the information flow up the chain in just a second. You say on page 65 of the report there were over a dozen agents, analysts, and 1 staff operations specialist in the original Crossfire Hurricane team, which would have included at least 9 FBI agents and supervisors involved in overseeing the Carter Page investigation. By my count, just what you've said in the report, looking at an organizational chart, we're talking probably at least a dozen individuals who were directly involved in the Carter Page warrants. The 4 times. Does that sound approximately correct?
That is. In fact, there's the org chart here at the end of Chapter 3. There are
exactly
3 different organizational charts, and people can see and follow this for themselves. But
so we've got about a dozen people at the FBI directly involved. That's a lot of people. The FISA court pointed out yesterday that an electronic surveillance application under federal law must be made by a federal officer in writing upon oath or affirmation, and those individuals swear to the facts of the application. Yet we now know that in October and then 3 times late, October 2016 and 3 times in 2017, these individuals deliberately, knowingly misled the FISA court. I mean, that's really the nicest way to put it. Basically, they lied to the FISA court to get a surveillance warrant of an American citizen. Why would so many people do that?
So we lay out here the reasons. As I said, there are multiple teams. There are some more senior people, more junior people. We obviously try very carefully to lay out who knew what when and which people. So I want to be careful and not.
Were they just all incompetent? I mean, all of these people, were they just couldn't they didn't know? I mean, they were competent enough to deliberately mislead the FISA court, to change submissions to the FISA court, to alter emails. I mean, so that doesn't sound like they're very stupid to me. But I mean, what's the explanation? Why over time? Why would all of these people 4 times over the space of half a year deliberately mislead a federal court?
So we ultimately we don't make a conclusion as to the intent here. So I want to be clear about that. But that was precisely the concern we had, is what you lay out. There are so many errors. We couldn't reach a conclusion or to make a determination on what motivated those failures, other than we did not credit what we lay out here with the explanations we got.
Yeah, so it certainly wasn't the reasons that they offered you, is what you're,
we didn't
is what
credit
you're saying.
that. And frankly, this is one of the reasons we weren't able to, but didn't reach a conclusion, is we now have the court weighing in and the court wanting to understand what happened here as well.
Yeah, so I think the scope here is what really alarms me. The number of people involved, directly involved at the FBI, the repeated decisions to mislead, outright lie to the FISA court, and the total implausibility of the explanations that these people offered you. I mean, again, maybe they're incompetent or maybe they had an agenda here. And I just want to put a fine point on that. Was it your conclusion that there was that political bias did not affect any part of the Page investigation, any part of Crossfire Hurricane? Is that what you concluded?
Not reach that
because I could have sworn, in fact, I know for a fact that I've heard that today from this committee, but that's not your conclusion?
We have been very careful in connection with the FISAs for the reasons you mentioned to not reach that conclusion, in part, as we've talked about earlier, the alteration of the email, the text messages associated with the individual who did that, and our inability to explain or understand to get good explanations so that we could understand why this all happened.
I think we're left with really, I mean, it's two possibilities here. You have three different investigative teams, as you testified earlier. You've got a dozen people at the FBI. You've got the decisions made over time to mislead the FISA court. Either these people were really incompetent and bad at their jobs, or they had an agenda that they were pursuing. And having an agenda, I don't care what word you put in front of it, political agenda, personal agenda, but whatever it is antithetical to democracy. Let me just ask you about the information flow up the chain. We know that Director Comey was briefed about Crossfire Hurricane in August of 2016. Who else knew about this? On October 14th of 2016, we know that Deputy Director McCabe gets a text message saying that the Deputy Attorney General wants to be part of the meeting, and the White House has asked the Department of Justice to host. Who at the White House knew about the Crossfire Hurricane investigation?
So, as you know, we're not the IG, the Inspector General over the White House or the Executive Office of the President, and so what we have access to are the records at the FBI and the Justice Department. So I can't answer questions unless about that as to who knew or who was involved beyond people in the Justice Department and the FBI.
I just find it very hard, I'll say in closing, Mr. Chairman, I find it very hard to believe that the Deputy Attorney General of the United States, the FBI Director, all knew about this, but that the senior leadership, the Attorney General herself, or for that matter, the President of the United States, would not know about a surveillance program of a major party candidate in the midst of a presidential campaign. I mean, that just boggles the mind. Thank you, Mr. Chairman.